Good morning, everyone. My name is Margaret Berry, and I've been on the faculty at Vermont Law School for the past several years. But most of my career was spent as a member of the faculty at Catholic University's Columbus School of Law. And at Columbus School of Law, I taught in the Families in the Law clinic there, and that was a domestic violence clinic. And we were part of the larger community in the District of Columbia that worked on domestic violence issues. And in that capacity, I got to know Leigh Goodmark. And Leigh Goodmark was an advocate at the time in the DV community, working with battered women, helping them to gain custody and visitation and child support, and getting protective orders to help them in the very difficult circumstances that they found themselves in, the work that all of us were doing in that community. I got to know Leigh better when she joined us as a visitor on the faculty at the clinic. And it was in that time that I got to learn up close and personal how amazing Leigh was as a teacher and as an advocate. I wasn't surprised that she went on to do so many other things in the community. But she went on also to be a teacher. She joined the faculty at the University of Baltimore's School of Law, and she became the director of their clinical programs, as well as the director or the co-director of their Center for Applied Feminism, and in that capacity continued to do her advocacy for battered women. Professor Goodmark is currently at the University of Maryland's Francis Key Carey School of Law, where she teaches family law, gender in the law, and directs the Gender Violence Clinic. Her scholarship focuses on intimate partner violence, and she's written numerous articles and other publications. And she's also written 2 books, one of which is, and many of you may know this, and she spoke about it at the last conference that we had on Restorative Justice. It's called A Troubled Marriage, Domestic Violence, and the Legal System, which was published in 2012. And it was named as the Choice Outstanding Academic Title in that same year. She has a new book, and I think she's going to talk about it a little bit today, Decriminalizing Domestic Violence, A Balanced Policy Approach to Intimate Partner Violence, 2018. It's coming out. Leigh has had a lot of pushback in her approach to domestic violence, but what she's been trying to address in her work and in her writing has been the problem that so many of us face when we're doing this work, which is that there are families that are being torn apart by the violence in the families, but the systems that we have to intervene are just simply not working well enough. And so while I've been part of the community that's really fought hard to make my clients safe, that safety that we're trying to provide has not provided the answers or the safety that our clients have wanted. And so I have to give it to Leigh for pushing the edge and trying to come up with other solutions. So Leigh, it's my honor to introduce you.
So what Margaret didn't tell you is that this is really all her fault because she was responsible for giving me my first teaching job. And so if you don't like any of this, go see Margaret Berry, and she can deal with it. So it's a privilege to be with you again today. You know, Jen suggested yesterday that we focus on the why of our work before we get to the how or the what. And yesterday you heard me say that I believe passionately that we need restorative justice in the context of intimate partner violence, but I didn't tell you why. And so today I'm going to give you my why, and then I'm not 100% clear on how the how and the what are exactly separate, but I'm going to give you a little bit of that too, and you can decide what they are. Criminalization is the primary response to intimate partner violence in the United States. And the title of my talk and the title of my new book is Decriminalizing Domestic Violence, a modest proposal that we de-emphasize the criminal legal response to intimate partner violence in favor of a multifaceted approach. That title makes people upset. It made people in Vermont upset last year when I was here, and there was a whole newspaper article about it, and you can read that if you like, but it makes people unhappy. So why would I put myself out there like that? Because criminalization of intimate partner violence is not working. And because it's not working, we are failing. And we need to not be failing. So we need to think more broadly about what will prevent and how to respond to intimate partner violence. And I believe that restorative justice can be part of that balanced approach. But to understand how we get there, we kind of have to go backward in time. You need to understand where criminalization comes from, and I know some of you do. But let me take you back to the year 1984. So imagine me standing here in my neon blue shirt from Express with my side ponytail with the yellow scrunchie, because it's 1984. Prior to 1984, anti-violence advocates had begun to argue that intimate partner violence should be treated like any other crime. Right? That was already happening, but 1984 is really the watershed year because three things happen in 1984. The first thing that happens is that the United States Attorney General's Task Force on Family Violence comes out with a report that says domestic violence is a criminal problem that requires a criminal solution. Fun fact, for those of you who care, the person whose quote that is the now judge and commentator Jean Pirro, who was part of that Attorney General's Task Force on Family Violence. But the report very clearly says this is a criminal issue, and that's how we need to deal with it. The second thing that happens is the case of Thurman versus City of Torrington, Connecticut. So for those of you who've only seen the Lifetime version, in Thurman, what happened was that Charles Thurman had been menacing, abusing, degrading, and really just tearing his wife apart for years. And the police in Torrington, Connecticut knew about it, and she had called them on numerous occasions until the time when she called the police and said, "He's doing it again, he's at my door, please come," and they didn't come. And he stabbed her repeatedly. And the police finally came, but they didn't arrest him. And he walked around the crime scene talking to people. Then he came and he assaulted her again while the police were there. And the police didn't arrest him. And then he took their baby and threw it on her body. And the police didn't arrest him. And it wasn't until he approached her while she was laying on a stretcher, being ready to be taken to the hospital where they would learn that she would be partially paralyzed for the rest of her life as a result of this act, that the police finally made an arrest. Tracy Thurman was awarded $2.3 million after the police failed to do this. And what that said to jurisdictions is, oh, this is gonna cost us money if we don't do something. So we need to find a way to respond to intimate partner violence that's gonna get us off the hook for liability, and that leads us to the third thing. The third thing was the Minnesota Domestic Violence Experiment. The Minnesota Domestic Violence Experiment was a study that looked at the impact of arrest on recidivist intimate partner violence, and what that study found was that arrest could in fact deter repeat violence. Now, the primary author of that study, Lawrence Sherman, said at the time, don't take this as gospel yet because every study needs replication. And without replication, we don't know that this is really going to work. And nonetheless, jurisdictions rushed because they had found their magic bullet in mandatory arrest. The idea that whenever police came to a scene, if they had probable cause to make an arrest, they should make that arrest. And thought, this is it. This is the thing that will save us, because if police have no discretion and they have to make arrests, we won't be on the hook anymore. And that was the third thing that happened in 1984. The first mandatory arrest policy actually predates the Minnesota Domestic Violence Experiment, but it's really after that study comes out that you see jurisdictions all over the country starting to adopt mandatory arrest laws. And over the next 10 years, states start to adopt a variety of policies that are intended to beef up the criminal legal response to intimate partner violence, policies like mandatory arrest and no-drop prosecution, my least favorite policy but for felony murder in the history of the world, which we can talk about at length at some other time. And then in 1994, we get the Violence Against Women Act, right? The first big piece of federal legislation specifically talking about the legal response. There had been federal legislation before this, but it wasn't about the law, it was about services. This is the first time where we say the legal system is responsible for dealing with this problem. And VAWA, not surprisingly, and it's not a coincidence, is part of the Violent Crime Control and Law Enforcement Act of 1994. So the Democrats wanted proof that they too could be tough on crime. Biden, who is former Vice President Joe Biden, who's the primary author of the Violence Against Women Act, says at the time, Republicans are finding out that it is no longer legitimate to say the Democrats are soft on crime because guess what? What has every major crime bill had so far? It's been a Democratic crime bill. A Democratic president wants 100,000 cops. A Democratic president wants to build 125,000 new prison cells, just in case you think this is an issue of party. And VAWA is very much a part of that carceral response to social problems that the Democrats come to embrace in 1994. VAWA invests heavily in the criminal legal system. In 1994, 62% of VAWA funding was dedicated to the criminal legal system. 38% went to social services. And VAWA continues to invest heavily in the criminal legal response. In 2013, 85% of VAWA funding was going to courts and cops and prosecutors and anti-violence agencies that were willing to partner with courts and cops and prosecutors. Only 15% is going to social services. In fiscal year 2017, VAWA's two largest grant programs, both of which are focused on the criminal legal response, provide $266 million to the criminal legal system. That's in contrast to, for example, transitional housing, which people subjected to abuse always say is the biggest need, which got about $40 million. So that's how we've prioritized in the policy area what we're going to do about intimate partner violence. Although the criminal legal response to intimate partner violence had been ramping up prior to VAWA, VAWA really stakes out the federal government's position that criminalization should be the primary response to intimate partner violence and puts significant resources behind that. So as a practical matter, that's really meant two things. One, criminalization is our funding priority, and two, VAWA has been used to promote criminalization policies like mandatory arrest and no-drop prosecution. There are monies that are specifically designed to ramp up those policies, and in fact, in the first iteration of VAWA, you had to have a mandatory arrest policy in order to get funding. You couldn't get money without it. That's been stepped back a little bit, but nonetheless, right? Mandatory arrest, preferred arrest, no-drop prosecution. I get chills up my spine when I say the words no-drop prosecution. That's how much I hate it. Those are the things that we prioritize in terms of our response. So, is it working? Depends. Depends on what you mean by working. One way to think about working is there less intimate partner violence since the inception of all of these policies? From 1994 to 2000, rates of domestic violence in the United States decreased. There is no argument about that. So did the overall crime rate. And between 1994 and 2000, as the overall crime rate is dropping, rates of intimate partner violence are dropping at the same rate. So they're dropping the exact same amount. What's interesting, though, is that between 2000 and 2010, while the crime rate continues dropping, rates of intimate partner violence drop less. At the same time that we are putting hundreds of millions of dollars into the criminal legal response, we're seeing less of a drop in the rates of intimate partner violence. Now, one might argue, well, isn't that because of increased reporting? There's no reason to believe that's true. There is no evidence that suggests that reporting has increased significantly during that time period. What we know is that intimate partner violence is dropping less than other crimes at the same time that we are targeting that system, that we are paying courts and cops and prosecutors to do this work. You might ask, is the criminalization of intimate partner violence deterring? intimate partner violence? And that's a really complicated question. Broadly, the social science research that exists does not find that the existence of laws criminalizing intimate partner violence deters the behavior. Now, of course, like all social science, that's nuanced, right? And you can get social scientists, but you can get it to say anything you want it to say sometimes. But here's what we know from the research. Arrest has effects on recidivism that range from modest to non-existent, and in some cases can exacerbate violence. So there are studies across the board on that. And this is why Sherman said, please replicate our research before you go use it everywhere. And in fact, Sherman, ironically, has become one of the largest critics, one of the most vocal critics of mandatory arrest. And his later work is really interesting in this area. One study found that the relationship between arrest and future violence was directly attributable not to anything about that arrest, but to pre-arrest risks in offending, right? So that arrest didn't change anything. It just happened to be with somebody who was already going to be a serial offender in some way. Studies on the deterrent effect of prosecution are similarly equivocal. One study found that conviction could have some effect on recidivism, but that effect disappears when you don't have ongoing monitoring and accountability. So basically, if you're not sitting on top of somebody, making sure that they don't reoffend, prosecution doesn't stop them from doing that. Studies find that incarceration alone has no effect at all on recidivism, and I'm going to argue that, in fact, it exacerbates recidivism, but that incarceration plus continued post-jail monitoring, again, sitting on top of somebody, may deter them from committing future violence. And, all of this, by the way, uses a deeply problematic measure, which is recidivism. And so if you think about recidivism, right, we measure recidivism through arrest rates and prosecution rates. Well, people who might be continuing to engage in behavior may not being arrested and prosecuted. And if you're a person who's been harmed and you've already been through the system one time and that system didn't do a thing for you, you're not going back. So recidivism is this deeply problematic measure, but it's the one that we have. So why? Why isn't any of this showing up in the research? The failure to find a strong effect of arrest or prosecution or incarceration may be the product of several different things, right? It could be about the inconsistent application and enforcement of the laws. Even in mandatory arrest jurisdictions, people say police still aren't arresting, so there's no real reason to believe anything's going to happen to you, so you just keep doing it. Again, it could be about the problematic measure. The use of recidivism is deeply problematic. Plus, intimate partner violence is an underreported crime in the first place, and much intimate partner violence is committed by the same people, which suggests that they are not deterred at all. I would add to that shame-based punishment is a deeply problematic way to address violence. And, it may seem a tenuous connection, but forgive me, in my home state of Maryland yesterday, you may know that there was a mass shooting at a newspaper, and like many of the mass shootings that we've seen, the person who engaged in that shooting was someone who had a history of violence against women before he committed an act of violence in the larger community. And it seems from early reports that what he was reacting to was the newspaper reporting about his history of violence against women, which suggests to me, as much of the research on shame suggests to me, that when we shame people for using violence, we make them more likely to use violence again, right? And for that reason, we may also not be seeing any impact of criminalization on intimate partner violence. So, is it working? I don't know. You can make that call for yourself. For me, the evidence is not convincing. I don't think it's working. But even if it were, we need to ask whether it comes at too high a cost. Intimate partner violence is part of what our response to intimate partner violence is part of what law professor Jonathan Simon has called governing through crime. Essentially, we've taken every social problem in the United States and said the way to solve this is by locking people up. Intimate partner violence is no different, and in some ways is kind of the prime example of governing through crime, an early adopter, as it were, of governing through crime, that the anti-violence movement, of which I am and was a part at the time, right, really believed that if we just made these problems illegal, they would go away. Governing through crime is a deeply problematic way to try to address social problems. It doesn't work, but also because we end up, right, with 2.3 million people in jail. And when you look at the numbers of intimate partner violence cases in the United States, if we arrested, prosecuted, and convicted every incidence of intimate partner violence in the United States, that is 800,000 incidents a year. By a third, we would increase the prison population of the United States. For those of us who have problems with mass incarceration now, criminalization of intimate partner violence, if done, right, if done to the nth degree, would make that problem so much worse than it already is. Talk about missing seats, right? We would have an entire empty room. Criminalization has done other things, though, that are deeply problematic. One of the things that I think was the biggest unintended consequence for those of us in the feminist anti-violence movement was the damage that it did to the people who we thought we were protecting. So criminalization has harmed people subjected to abuse in a number of different ways, right? First, mandatory arrests gets adopted. Guess who gets arrested more? Women. Right? Rates of arrest of women, sky high in lots of jurisdictions, both single arrests and what's called a dual arrest, right? Both parties get arrested. Not surprising. Cops show up at the scene, they look at both people, they say, well, you say this, he says that, you got scratches, she's got a bruise, I'm taking you both in, right? And dual arrest goes through the roof. And there are some jurisdictions, Connecticut particularly, in the near area, that are still really grappling with how do we deal with this problem where we've got arrests of people subjected to abuse just sky high. Criminalization has also meant increased interaction with the state in a number of different ways for people subjected to abuse, most notably through the child welfare system, and the interactions of the criminal system and the child welfare system and intimate partner violence are deeply destructive, particularly for families of color, which are overrepresented in all of those systems. The operation of mandatory policies has kind of psychic harms as well, because what it says is, people who've been subjected to abuse, we don't believe you have the power to make decisions for yourself. We don't believe that you're fully competent to make decisions for yourself. We need to do that for you, or you're going to get killed. I got to tell you, I've represented, at least 1,000 people at this point. And while some of them were coercively controlled, and we can have a conversation about what that means, I have never had a client who was so controlled that she or he could not tell me what she needed, what she wanted, and how to deal with that. They didn't need the state to come in and tell them how to do it. But we've infantilized people subjected to abuse, and we've said, unlike any other crime victim, you guys can't make up your mind. We're going to do it for you because we love you, because we care about you, right? And I think that's a deeply problematic stance to have taken. The harms to people of color that criminalization has created are immense. The racism that infests the rest of the criminal legal system is absolutely within the intimate partner violence part of the world as well. These laws are disproportionately enforced against people of color. In Milwaukee County, for example, 24% of the population was people of color, 66% of the defendants in intimate partner violence cases. There's a new study that's just come out on the criminalization, on the enforcement of criminal stay-away orders, which finds, again, disproportionate use of these felony violations of criminal stay-away orders against, particularly in this place, the indigenous population and African-American populations. So we're seeing the same racism writ large in intimate partner violence as we are everywhere else. There's the social stigma of incarceration. Adam's already talked about that. I don't need to talk any more about it. There are the collateral consequences. Again, Adam's already talked about that. But I want to pay particular attention to employment. Here's one of those places where we were unbelievably short-sighted. When you go to jail, what happens to your job? It goes away. And when you come out of jail, what happens to your ability to get a job? That goes away too, right? And guess what highly correlates with the commission of intimate partner violence? Male under and unemployment is the most significant predictor of intimate partner violence and a serious predictor of intimate partner homicide. The solution we've created is driving the problem. Similarly, community dysfunction, community instability, highly correlated with intimate partner violence. What happens when you take the wage earners out of your community, leave the kids without children? or kids without children, leave the kids without parents. You have community instability. And guess what drives intimate partner violence? Community instability. I think the biggest thing for me, though, is something that the law professor Spirit, has called the cycle of destructive masculinity, and the ways in which incarceration and violence and trauma all interact, right? So you take somebody who may have problematic ideas about masculinity and the use of violence in a relationship, and you send them to prison, where, one, they are exposed to trauma, two, they often become victims of trauma, right? They experience that trauma during their incarceration, and they're put in positions where those same problematic notions of masculinity become protective in some way. And then they come out and they go back into communities with those same problematic notions of masculinity, with the same belief that violence is what protects you from harm, but with the added trauma of having witnessed or being subjected to violence while incarcerated. And once again, and suffering, right? Suffering from PTSD, suffering from the effects of trauma. And then, once again, what is highly correlated with post-traumatic stress disorder? Commission of intimate partner violence. The solution we have created is driving violence. We are not solving the problem. We are making it worse through criminalization. So, is criminalization working? I guess it depends on your perspective. My answer would be no. And I hope that I have convinced you that the answer is no. So, criminalization may not be the best way to deal with intimate partner violence, and so we're looking, right? We're searching for other ways to do this work. But as I said yesterday, intimate partner violence is in some ways the third rail of restorative justice. It's the one thing that we've been told maybe this is a bad idea in this context. And for years, people have cautioned that restorative justice is problematic at best in the context of intimate partner violence. I disagree with that too. Restorative justice is not for every case. It is not for every context. We are mistaken and we are misguided if we think that the way to solve this problem is just to take RJ and put it where the criminal processing system, and you'll notice I don't use the words criminal justice system, I just don't anymore. I use criminal legal system. I think that's a more descriptive term. Thanks to Joanne Belknap for giving me that. But really what we have is a criminal processing system. And if you think we're gonna take a process that requires nuance and thought and preparation and time and plunk it down and replace a criminal processing system with it, you are sorely mistaken and we will fail. And we'll be right back where we started. So it's not for every case, it's not for every context, but restorative justice has a role to play in decriminalizing domestic violence, in de-emphasizing the criminal legal response and seeking alternatives. So if you're on board now for the why, here's some of either the how or the what. Again, Jen will have to teach me the difference between the how and the what. I'm not entirely clear. But here's one example of how it can work. And again, you know, in the category of things that are deeply frustrating, if I were John Braithwaite and Kathy Daly, I would be so frustrated because in 1994, they gave us an idea of what this could look like. They laid out kind of what a restorative response to intimate partner violence could be. And that structure that they laid out in 1994 is just as relevant for addressing some forms of violence today as it was when it was originally conceived. You start with self-sanctioning, right? The idea that people need to regulate their own behavior. And if self-sanctioning doesn't work, then families and communities can step in informally to try to do some of that work. We have ceded responsibility for policing, and these are my air quotes, policing intimate partner violence to the state. But families and communities should be doing some of that work, and we can talk about what community means in that context. Informal sanctions. If those informal checks are unsuccessful, then we start to do formal intervention. And in Braithwaite and Dalys Pyramid, those informal social sanctions are followed by a first state intervention with police issuing a warrant, which is a very Australian, I think, way of looking at it. In the US, it doesn't exactly work. It doesn't map correctly. But in the US context, this first state intervention could look a little bit different. Police could be called, and depending upon the severity of the allegations, could issue a warning of some sort, but not seek an arrest warrant, not have the intention to act upon that warrant, particularly in jurisdictions with mandatory arrest or preferred arrest policies. Because the goal at that point in the intervention is to create disincentives to violence without actually instituting criminal proceedings, a U.S. pyramid might just be some kind of heightened monitoring. And that kind of monitoring is actually being piloted in a number of jurisdictions, including High Point, North Carolina, through a tactic called focused deterrence. And focused deterrence, what that does is it classifies people based on the frequency and the severity of the offenses that they commit. And it tries to figure out kind of who are the people with whom we could just do these minor interventions and have a real impact, and who are the people we really need to be paying time and attention to because they're going to do serious violence. So with the harmed person's consent, right, you could have heightened monitoring, including the police dropping by or driving to the party's home with the person's consent, and that is, for me, a key part of all of this, that the person who's been subjected to harm has agency, has voice, is able to shape these interventions in ways that meet their justice needs. But knowing that the police are watching your behavior could be that kind of sword of Damocles that is hanging over somebody's head that works in the same way that Braithwaite and Daley describe having a warrant but not executing the warrant. What have I got, Stephanie? I'll get there. Okay. Middle tiers, you could look at restorative conferences, and one of the things that they talk about, I'm just going to skip through a bunch of this, one of the things that they talk about a lot is the need for repeated conferences, and those of you who do the work know this is not a one-shot deal. And what's interesting, I think, about the response to repeated conferences is the idea, well, that means we failed, right? If we do one intervention and the harm doesn't stop immediately, we've failed. Well, we don't say that about people who have repeat interactions with the criminal legal system. People go in and out and in and out and in and out, and we don't say the criminal legal system has failed. So we need to have the same patience with the process around RJ that we have with the criminal legal system. Civil law could also provide you with an additional layer of accountability. Things like family law and protective orders and tort law, all of those are tools we can use in lieu of criminal legal system intervention. And though those are complicated in some ways by the way that particularly in the protective order system, the criminal law has bled its way in, right? Enforcement of a protective order is through the criminal process. We can be thoughtful about how we might use those tools. It's important to note that the apex, the top of Braithwaite and Daley's pyramid, is incarceration, and they recognize that sometimes there are people who really can't be among us. And I think even in a book called Decriminalizing Domestic Violence, I recognize that too. There are times when we need people to be away from us, to make others safe, to make ourselves safe, and we need to be thoughtful about when and how we do that work. And the how, for me, is particularly important. We don't have to send people to inhumane places. The punishment is the loss of liberty. The punishment is not the degradation and horrible conditions and the trauma and the violence that we inflict on people when they're there. We, the anti-violence movement, needs to be about prison reform as much as we're about anything else. There are other hows as well, right? There are other ways we can get to this place. We could talk about community justice forums. We could talk about truth and reconciliation. We could talk about preventative circles and COSAs. I'm willing to bet that many of you have a better how than I do, and that's what we need to be exploring together. So the title of my book, I will admit, is a little bit of a bait and switch. By decriminalize, what I mean is de-emphasize the criminal legal response. Ending it altogether is unlikely, and we have to have some mechanism to create safety in those cases where people just aren't going to stop being violent in any other way. But adding restorative justice to the menu of options that we have to respond to intimate partner violence expands our possibilities for meeting those needs. It avoids inflicting further harm, both on those who've done harm and on those who've been harmed. And it bolsters the effectiveness of that criminal legal response in cases where somebody otherwise just can't be deterred and we have to ensure safety in some other way. Restorative justice is not the entire answer. And in my book, I argue that intimate partner violence is an economic problem. It's a public health problem. It's a human rights problem. But it's also a community problem. And restorative justice has to be part of a more thoughtful response to intimate partner violence. Thanks.